Part 10 Personal Insolvency Agreement is a formal alternative to bankruptcy that allows an insolvent individual to negotiate a legally binding arrangement with their creditors to settle outstanding debts without becoming bankrupt. Part 10 of the Bankruptcy Act 1966 is designed for people who are unable to pay their debts as and when they fall due, but want greater flexibility than bankruptcy or a Part 9 debt agreement can provide. Unlike a Part 9 debt agreement, there is no income, asset, or debt limits, making a Part 10 a common option for business owners, company directors, and individuals with significant tax debts or complex financial affairs. The process generally begins with the appointment of a registered trustee who prepares a proposal for creditors. That proposal may involve a lump sum payment, periodic repayments, the sale of certain assets, or other negotiated arrangement that provides creditors with a better outcome than bankruptcy. Creditors then vote on whether to accept the proposal. If the required majority approves it, the agreement becomes legally binding on all participating creditors. One of the major advantages of a Part 10 agreement is that it can allow a debtor to avoid many of the consequences associated with bankruptcy. Depending on the terms negotiated, it may be possible to retain certain assets, avoid the standard 3-year bankruptcy period, and reach a more commercially practical outcome for both the debtor and creditors. It's also commonly used to deal with substantial tax debts, joint debts, and other significant financial liabilities. However, a Part 10 agreement is still a form of personal insolvency and carries serious consequences. The arrangement is recorded on the National Personal Insolvency Index, can affect a person's creditworthiness, and may impact their ability to act as a company director or obtain finance in the future. If the agreement is breached or terminated, bankruptcy may still become a real possibility. Because Part 10 agreements involve trustee appointments, creditor negotiations, voting requirements, and significant long-term consequences, they are often used in more complex insolvency situations where bankruptcy is not the preferred outcome. Understanding whether a Part 10 agreement is suitable, what debts can be included, and how creditors are likely to respond can make a significant difference to the outcome and your long-term financial position. Contact us today for a free 30-minute consultation with one of our experienced team of insolvency professionals and let us help you protect your rights.